everybody, it's the duty of all subcommittee members and members of the State Bar to avoid conflicts of interest or appearance of conflicts of interest. Does anybody recognize a conflict that they might have or an appearance of conflict of interest they might have? Hearing none, let's go secondly to approving the minutes of the last meeting on May 24th. Has everybody had a chance to read those minutes? Any changes, objections, modifications? Is there a motion we approve?
So moved.
Second?
I'll second.
All right, all in favor, raise their hand. It's just okay, minutes are approved. So what I'd like to do starting this, I did send out an email to earlier this morning to members of the committee that sort of set out a few of my thoughts, but I'd like to review briefly kind of where we are and where we might go. As all subcommittee members recall, the larger ethics committee sent this back to us to examine possible changes in the rules of professional conduct under Rule 1.6 or under terminology, because of the large number of comments that were received with our correct opinion of NRA Con 20 FEO 6. So that's where we were. It got kicked back to us, and we have done a thorough deep dive into other states' rules and their modifications. We've done a thorough dive into what possibilities we have. In fact, our last meeting, we were set with 4 or 5 possibilities and alternatives. And we kind of seem to land on our 1C option, which included that had public record as being outside of the confidential information. But we also ended up discussing issues of what's embarrassing to the client, and whether or not the client should have veto power. And so in the email that I sent out to everybody just a little while ago, I'm just expressed some of my concerns that as we start tinkering with these rules and start recognizing the impact and consequences of the changes and how they ripple through the other rules, and also how we're shifting the sort of balance of power away from the client and towards the lawyer, giving the lawyer the control of the use and disclosure of certain information that has previously been the client's. And I think that's a trend that perhaps we ought to be very cautious about treading down that path. I do think that the other issue that came up was embarrassing information. And in my email, I mentioned that that's a subjective measure, subjective to the client. You know, what's embarrassing for a lawyer or not embarrassing for a lawyer may be really embarrassing to the client. And so there may be some real issues about trying to circumscribe or define embarrassing information. And the final issue is Jack on board. He's not here because one of the issues that he brought up earlier was, you know, in his work at legal services, he has to provide information either to his board or to supervisors. And so he was concerned about whether or not 1.6, as it's presently written and interpreted, would proscribe that kind of activity. And the other issue that has come up is whether legal knowledge and legal research is outside of the confidentiality of information. So So, I think I was hoping we could plow through a lot today and have a report in October for the Ethics Committee. So I think I know where Amy stands. I think Amy wants 1.6 to stay as it is. And Todd, I think Todd, I know where you stand, that you want 1.6 to remain as is. Am I correct in both of those?
Amy?
Yes, thank you for hearing me. You are correct.
Yes, you are correct. Having gone back and read all of the stuff even more, I am even more convinced that we ought to maintain status quo.
Yeah, and that's why I put that T.S. Eliot poem to begin with, because we have really gone around the flagpole a number of times. Bill, let me ask you, because I read and reread your comments from last meeting on the minutes that Suzanne did. And we've all had a time to reflect on this. Give us your thoughts.
Well, I'm very in favor of changing Rule 1.0B to exempt from confidential information public record. I'm okay with legal knowledge and legal research, that's fine, but information contained in the public record ought not to be confidential, in my opinion. It would fall outside the privilege if it was ever a controversy about it, and it just ought not to be confidential. A lawyer ought not to be prohibited from talking about information that's in the public record. That's my strongest feeling about the whole matter. And that may take care of most of the concerns about 1.6. I don't have a strong feeling about whether 1.6 has to be changed or not, but I can be persuaded on that.
What about as embarrassing information that's in the public record? How does that square?
I don't think we ought to touch that personally, because I don't see how you can prohibit somebody from talking about information that's in the public record, no matter how embarrassing it is.
Ellen, you want to step into this?
Yeah, so but I'm going to add another question. So you may not want me to, and that is, what is the public record? I don't think we can assume that we have clarity on that. I tend to agree with Bill right now in terms of the logic of excluding information that is in the public record. I'll be honest, I don't have a lot of thoughts right now on knowledge and legal research. I find the additional sentence in 1.6 almost unnecessary, right? It's unlikely that a client would read that. I mean, if that, to me, of course, a client could request that. And if that is, but it's not adding an affirmative duty on the lawyer. And so what does that additional sentence in 1.6 add, unless we're going to say, lawyer, you got to tell your client, I don't think we want to do this, but you got to tell your clients this is what confidential information is, and you can request that it be kept confidential. But as it stands, I don't think it provides any clarity. But I do have a question about what is the public record.
Bill, you want to define public record for us? Because you've seen the view from the bench that the rest of us haven't. But
sometimes it gets a little bit difficult to try to separate this question from questions of privilege, because it may not be the same all the time. But the information that's disclosed to a third person is generally outside the privilege. It may not be public record, but things that are in court filings, unless they're sealed, things that are, which includes transcript testimony, which includes argument before the courts of appeal. I mean, includes anything that's part of a court record.
So it's a public court record. It doesn't include
Well,
a
it's
congressional record or
things that would be considered of record under the law, such as deed filings and that kind of stuff. I mean, anything that would be considered notice, public notice, would be part of the public record, which would include, in a lot of cases, newspapers.
You know, we do have, you know, some courts that are not courts of record. The district courts are not courts of record. And more and more in Superior Court, we're getting these, especially in the administrative side of Superior Court. You know, we don't have a court reporter. We have a, you know, a recording device that records the sessions of Superior Court, which really kind of muddies the water a little bit more. But some, you know, some administrative hearings likewise are, I think, have no court reporter that in certain circumstances. So it really, you know, are we going to say that the public record is that information that is either filed or taken down and transcribed? Because district court is just going to be the Wild West, I think, in district court.
If there's testimony in district court that's heard by people other than the client and the lawyer, then it's on the public record as far as I'm concerned.
So because you asked me, Eben, and I know Colin has his hands up. I want to get to him, but so for me, that's a little broad. And I think at some point, and y'all can refresh me because I did miss the July meeting. If there was a July meeting, I missed the big meeting. I was at a funeral, but why didn't we discuss using generally known as opposed to in the public record?
Yeah, we kicked that around last time, and I'll call on Colin in just a minute. And I think that there was some as much difficulty as we're having defining public record. It was almost impossible to define generally known.
But we use it already. In other words, we use it in the rules, and so a lawyer may have a better idea of what that means. I agree we shouldn't try to define it, and this may lead me back to where Amy and others are, which is we shouldn't do anything with this. So I appreciate y'all being patient with me, but I think that public record undefined is arguably incredibly broad. And an example where you have a hearing where there's no transcription, there's one other person who happens to be in the courtroom. To me, that's not necessarily, to me, that's a little broad.
Yeah. Colin, do you want to say something?
Yeah, I mean, I agree with Judge Pittman's issue about the information that comes out, and you know, I'm not sure that public record is the terminology that we might want to use. I mean, that's defined, and there's lots of law about that. I think in Chapter 133, when we generally speak about documents that are part of state government, but it seems like to me that the information that's in the public domain, if someone testifies in an open courtroom, it seems to me that what is said should not be viewed as being, the lawyer shouldn't be restricted to talk about that. I mean, and from a practical matter, I mean, doing things like CLE, I mean, if you want to talk about a case, then you ought to be allowed to talk about those things that took place in public, you know, not confidential communication with the client or things that you gained in some confidential manner, but you know, to be able to discuss, you know, what a witness said or did, or the events that took place in a courtroom, seemed to me to be unnecessarily restrictive to try to prevent the lawyer from discussing those issues.
So, you know, I guess what we're saying is that that once something becomes public record, it's no longer the client's information. It becomes anybody's information, including the lawyer. And I've forgotten, it might have been Amy last time, or maybe Todd, I've forgotten that it's just, you know, I think it was Amy said that, you know, if a lawyer is disclosing the information of a client that she represented, that carries more weight than a third party. And also is a direct link to the client, who, you know, whose and whose information it traditionally has been. So is that kind of what we're saying, Bill and Colin, that once it becomes public record, it's a free for all, basically, even if embarrassing?
I think so. I don't see, I can't see a legal or ethical reason to prohibit a lawyer from disclosing information that anybody else in the world could disclose.
Agree.
Even if your client says don't do it.
Right. Because I actually really want to be in agreement with you guys. You know, I struggle with this so much because I want to agree with you. My concern is I think what's protected under 1.6 is greater than what's protected under the attorney-client privilege. Like the ethics rules go further because of this reason, because if it's embarrassing and the client doesn't want it out there, they do lose control when it comes to privilege, right? It's narrower. What they don't lose control over is the attorney-client relationship and what they want their particular attorney doing. And like, I take the CLA point, I take it could be in the papers, like it could be on the front page of the New York Times, and it's really frustrating. I just think the intent maybe is different to create something that is broader than attorney-client under our standards. So, but again, I really want to agree with you. I'm just struggling. So
I've looked at this as like an agency relationship. And to me, you work for the client. And if the client tells you, no, you can't talk about my case, you can't talk about the case. That's your client. That's who's paying you. That's, you know, it's an issue of loyalty to me at that point in agency. So I don't understand how you, if your client says don't do it, how you can then turn around and do it.
The rule says not reveal confidential information. I don't see how we can designate something confidential information when someone is testified in open court about it. I mean, it's no longer confidential information at that point. I mean, whether you say you acquired it in a professional relationship or you acquired it sitting on the third row of the courtroom seems to me to be superfluous, but it's not confidential information.
it
It
doesn't
doesn't
say
say
that.
confidential information.
It just says information.
I
Just
thought,
as
I'm sorry,
information.
I thought looking at the discussion, I thought it said not reveal confidential information.
No, the rule says a lawyer shall not reveal information
Information, that's right.
acquired during.
Yeah.
That's right.
Yeah, and I think, Ellen, the generally known is fairly circumscribed in Rule 1.9. And Suzanne helped me on that, but it's just like it's where you can use certain information, but you can't disclose it.
Right. It's limited in Rule 1.9, which
Yes.
most people don't
Yes.
realize. And also the comment that talks about generally known specifically said just because something is in the public record does not mean that it's generally known.
Correct.
Yeah.
Right.
And I'm fine with adding or is generally known to that proposed part change to 1.0 about the public record.
Well, I was proposing generally known as a more narrow way, actually. I mean, as an alternative to the public record, a more narrow alternative to the public record. So it covers if it's on the front page of the New York Times, right, then it's more narrow than the example of there only being one person in the courtroom, although I appreciate the comment that once someone's testified in open court, but generally known as an alternative to the public record, not as an in addition to.
Darren, I see you've raised your hand somewhere.
Yeah, I don't know whether this adds to the discussion, but I always think about how it affects the administration of justice. And we had a FEO back many, many years ago where a lawyer was funding this this periodical that showed mugshots. I don't know if Suzanne remembers that or not, and whether or not they could, they could financially support the mugshot thing, where they would basically put in every convenience store mugshots of people who have been arrested soon. And they found that, if I recall correctly, and Suzanne might remember better than I, that was an administration of justice issue. I mean, that sort of impugned the legal community, because it created, it went against what we as criminal lawyers would be expected to do, of protecting our client. And those are all public records. When that, it didn't talk about any confidentiality. It talked about stuff that was public record. It was their arrest. And I just call into question about that. That concerns me about how it looks for lawyers to be out disclosing whether it's confidential information or not, but just presenting a negative view of a client or a potential client. So that's what I've got to say.
Well, I think we ended up just doing an EA or an ED on that one, and it was a little bit different because it wasn't their client; it was just everybody that got arrested. But I think it was just, the whole thing was just kind of distasteful and didn't reflect well on the legal community. But another thing I wanted to bring back to focus is the fact that there are options for lawyers. They can get the consent of their client, or they can use a hypothetical.
Right.
So it's not like we're saying you can never talk about this. I mean, the reason that we have this one before us is because the client said no. And to me, that shuts it down. To me, the client says, no, you can't do it. But generally speaking, you can get consent, or you can use a hypothetical. It's not that you cannot talk about anything ever.
So I'm trying to put this on a balancing test and trying to figure out what are the positives for going, Bill, your route, and what are the negatives, and whether or not the negatives outweigh the positives, or whether they're, the positives that you're seeking, like, for example, CLE, can be met with alternative means, like Suzanne pointed out. But so I think that Todd and Amy see the balance towards negatives. Anybody else want to weigh in on that? Ellen, if you put this on us, what do we gain by changing the rule? And if we do change, what are some of the adverse consequences that occur, such as Darren points out, administration of justice, as Suzanne points out, loyalty to the client. This is not an easy scale to balance here.
No, and I think those are at risk when it is as broad as in the public record, particularly given that we can't define in the public record. And so, I tend to come down in the middle more. At the same time, I'm more sympathetic to the argument. And I think there's less to lose when the information that the lawyer wants to talk about, not in a hypothetical or without consent, is information that is, on the front page of the Wall Street Journal. To me, that's different. But I think I'm in the minority there, and that's okay. But in terms of what there is to lose was your question, I think there's a lot less in that case.
But still, if all that information, like, you represent somebody and that's all on the front page of the newspaper, but your client comes to you and says, I know this is all over the newspaper, but you're my lawyer and I don't want you talking about it.
Then you can't talk about it. I absolutely agree with that.
Well, that really, I think, throws a fly in the ointment, because it puts a duty on the lawyer to give the client informed consent and sufficient information to let them know, not only at the outset of the case, but at any time that the lawyer seeks to disclose information that is, in the public record, so to speak. And so we're back to this giving the client the veto power, which is really 1.6.
Right.
We're really just back to,
Square down the middle. I mean, it is 1.6. You can get consent, as Suzanne points out, and solve that problem. But I think if we say the client has a veto power, then I think implied in that is a duty on the lawyer to inform the client at all times when there's going to be any disclosure of that information. Anybody else see that differently, or am I just being myopic about that?
Read the addition to 1.6 as written right now as putting a duty on the lawyer. If our stance is this puts a duty on the lawyer, then we need to be clear that it puts a duty on the lawyer.
well, I think
In my opinion,
the duty's already on the lawyer.
It's already on the lawyer.
Right. Yeah.
then we don't need to add that last sentence.
But that sentence is in there if we're changing Rule 1.6.
I agree with you, Ellen. We don't need that sentence, quite frankly. I agree with that. It's already there.
Colin, you got some wisdom there. Does a client have veto power, and if so, how do we structure that in a way that that works? And once again, what do you see as the balancing here, the positives for changing the rule? That is, and what I'm hearing is basically it's just CLE, or if we change the rule, all of a sudden the lawyers that practice today are a different generation than many of us. This stuff is going to go out on brag boards, websites, podcasts. It's going to be disseminated
That's my concern.
everywhere that it can, across the universe of possibilities, not just at CLEs. And that gets really reckless, sometimes. And I think that's just a Pandora's box. But anyway, help us, Colin, sort through this.
I don't have any franchise on the wisdom on this, but it just seems like to me that information that was generally available to the public, whether it's in the public record or whether it comes from the witness stand in an open courtroom, should not be treated as confidential information, which deserves some type of protection. I mean, I think we'd need to rely on lawyers' discretion in not doing things that are detrimental to the client. But sometimes during the course of a trial, you might people may make public statements during the course of the trial about what went on in a courtroom, and I don't think they ought to have their client's consent if it's something that was information that was available to the public. I mean, I guess it's just sort of a predisposition towards kind of open records philosophy of dealing with government that, I don't see why we put that burden on the lawyer when everyone else in the courtroom has the ability to talk about it. I understand the unique position of representing a client. I think we have to put a little bit of faith in the lawyer to do things that are not detrimental to a client.
But I guess my question is, why? What's the net positive for letting the lawyer freely own that information forever and forever once it's public? What is actually gained from that is my question. That's what I'm trying to put on this scale of trying to figure out what are the net positives and what are the potential negatives. So help me get a net positive. How does that help the lawyer, the client, the administration of justice? What does it do, actually, that's positive?
Well, I mean, the environment I've practiced in for 40 years is, I mean, lawyers talk among themselves about this. I mean, I might be trying cases or involved in case and seek the advice of someone else. And those experienced lawyers may talk to me about things that went on in their case that not trying to disclose privileged information, but they may talk to me about their experiences and their impressions and things like that. I mean, to me, that kind of communication is also prohibited. I mean, if you say you can't release that information, then you can't release it to another lawyer over a cup of coffee who's trying to figure out how to represent his client to the best of his ability. I mean, it's a blanket shutdown of communication about it. And I just think that.
I'm sorry, Colin. We talk about that a little bit in the mentoring opinion, I think, and we talk about when lawyers talk between each other that they still have a duty and that they need to be doing it in the form of a hypothetical.
But I mean, it's sort of hard to say, you know, hypothetically, if you were trying the Speaker of the House and you asked him a certain question and hypothetically his answer was, I mean, that seems to me that that gets sort of a ridiculous impediment to not move us in one direction or the other. I just have, maybe I have an overconfidence in lawyers' ability to use this type of information in a way that's productive and helpful to the bar, as opposed to thinking that, you know, they're going to use it for some other nefarious purpose. And, you know, I may be, you know, Rebecca of Sunnybrook Farms about that and just not, you know, looking at it right. But it I just can't understand the logic of why we would make a rule that says, you know, or try to enforce a rule that says one person can take this information that's out there in the public domain and talk about it and use it, and this other person can't do that. I mean, it doesn't seem logical and consistent to me with the way rules should be.
It's not logical. It's not logical, but that's, you know, I think that it's the other things on the equation. I think the loyalty and the administration of justice that weigh in on the other side. Professor Ribeiro, you got some from the ivory tower, some help for us here? I mean, or is it too cloudy up there?
Thank you. I'm just here to hear the discussion, which I appreciate the opportunity. I guess my only point was something that was already referenced, I believe, by you, Mr. Rolfe, which is there's a risk component to this, which is if lawyers are free to talk about things that, you know, without their client's authorization, even though it might be in the public record as some kind of, you know, legal fiction of constructive notice, there's a risk that attorneys might end up talking too much. And I understand Mr. Willoughby, you know, faith in lawyers is just, you know, there's a risk component that lawyers might speak too much. So, you know, clients should have a saying. So I think I agree with that. But I'm just here to listen.
Thank you though for weighing in on that.
Eben, I mean, I think this discussion sort of points out what our charge is. I mean, this is obviously a very close question. Our charge is to protect the public. And so if our charge is to protect the public, and this is a close question, and as Suzanne points out, there are other options set forth in the rule, like obtaining informed consent or using hypotheticals. I mean, there are some protections that will allow lawyers to gain this, but in order to maintain confidence, the public's confidence in the legal profession, you know, we ought to be erring on the side of protecting the public. the discussion about, what if some third person in the courtroom or some news reporter hears a testimony or sees a document and runs out and puts it all over the internet. That's fine and good, but the only people in that courtroom who has an attorney-client relationship with that client is that lawyer who this rule says don't disclose it without the permission of your client. We have the privilege of this license to represent the public, and these rules go along with that. And in that circumstance where someone, courts are open. Anybody can walk in and hear a witness testify. That person who walks in is not subject to an attorney-client privilege with the people sitting at, counsel table. And so my view is, we have a heightened obligation to abide the wishes of our clients, unlike anybody else in that circumstance. And I think that comes with the duty to not disclose information that the client may not want disclosed or that may be embarrassing to the client, especially when we have protections built in by the rule in the way of informed consent or hypotheticals. It is the client's case still. And my view is that the client ought to have the final say over whether or not that gets disclosed, and protecting the public ought to take care of that very issue the way the rules are written.
Yeah, and Colin, I'd like to respond briefly to your issue there. And these are rules of reason, and maybe not logic, but rules of reason allow some latitude, and certainly it may not be implied consent that a lawyer may seek advice or some feedback regarding a case or cases that are going on. But I see that as not a transgression, but a rule of reason that would imply a lawyer's ability to seek advice and seek feedback or consult another lawyer in their cases, because that's normally what the dialogue is. We seek advice, we seek feedback, consultation, and we give it back to other lawyers who ask us about cases that are going on. Brian, you're the ethics guru of on Mount Olympus up there. You've been amazingly quiet, and I've been waiting for you to sort of part the waters here and lead us to the other shore.
I was actually just thinking, where does Rule 3.6 on trial publicity fit in here? And the general notion that we have here that, we have an express rule that says that a lawyer who has participated in the investigation or litigation of a matter, shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing that or an adjudicative proceeding. And it kind of, I guess, brings about the inverse suggestion that, well, does that mean that a lawyer can say something or respond to an inquiry from the press? Lawyer, you just represented a client in a particular case. You had this outcome. We see the order that the judge issued. What's the next steps, lawyer? Is this thing going to be appealed? Maybe it's a court of appeals opinion. Are you taking this to the Supreme Court? Were you satisfied with the outcome? The case is resolved, and maybe this is somebody coming to you 2 weeks after that order actually gets issued. It's not necessarily, the statement isn't necessary to carry out the representation, but is the lawyer supposed to say, I cannot comment without my client's consent, or is that something that's helpful to inform the public of the status of a particular legal matter? Can they make that comment? And that's the thing that I don't want to, I feel like there's, and I'll just kind of say generally, I struggle with this the way that, Amy has said, I want to land on one side, but I struggle with this because I want to balance, like Todd said, the protection of the public. That is the purpose of the state bar. That's the purpose of the rules of professional conduct. But it also is something that I don't want the rules to put an unnecessary muzzle on those that are involved in the legal process. I think the things that Judge Pittman and Colin have been articulating really go back to that Virginia Supreme Court opinion, where that Virginia Supreme Court back in, I think it's 2014 or 2013, basically said, the general notion that a lawyer, the lawyer for a particular client may not speak on information contained in the public record really doesn't serve the purpose that the rule on confidentiality is meant to protect. Putting that sort of restriction is not something that at least it's not so much that it doesn't serve any purpose, but that it doesn't serve a sufficient purpose to overcome the lawyer's own First Amendment right to freedom of speech. And that's where the court kind of drew the line to say, while you're in the representation and you're dealing with confidential information or just information acquired during the course of the representation that's not in the public record, then there's a prevailing reason to restrict the lawyer's First Amendment right. But once the information essentially is let out and put into the public record, or generally known, whatever you end up calling it, that the reason to put that restriction on the lawyer's ability to freely speak is lessened. And I guess I'm personally kind of landing in this spot of either leaving everything as it is, because we clearly have a difference of opinion just amongst this very intelligent group of individuals. So you can imagine the difference of opinion that we would have out there. And when you don't have some sort of real strong consensus, I have a bit of heartburn in the thought of changing such a foundational rule that we have in our profession. But I also kind of recognize that if there's any desire to allow that which is in the public record or generally known to be excluded from the definition of or the scope of confidentiality, I see the merit that we see in other jurisdictions where they say, but a lawyer cannot disclose that which would be embarrassing or detrimental to the client. That there's a check on that lawyer to say, lawyer, you subjectively need to look into that. And the first time I read that, I thought that was way too squishy. I didn't like it. Thought we shouldn't even touch that, the way that you said, Judge Pittman. But I see now that that is a check that is put in by these other jurisdictions that have that type of language, and I see the reason for it to basically say, lawyer, ultimately, even if something is in the public record, even if it is generally known, if this is going to be detrimental to your client, it is your responsibility to not disclose that. And if you do, that's a violation of the rules of professional conduct for which your conduct can be addressed. There's nothing that screams this is the perfect course of action to me. And so that's where like I said, as much as I kind of feel like it maybe that would be a reasonable thing to allow that sort of public record, generally known information out there, as long as it's not embarrassing or detrimental. I still find myself wary, or maybe just very cautious about that because of the importance of the rule that we're dealing with. So that's my non-answer, very long-winded non-answer.
Well, I'm trying to look ahead to reporting to the full ethics committee and having all of us there to weigh in. And so Suzanne, Brian, help me here. It seems like we're in a situation where we need to offer alternatives to the ethics committee. Status quo, in re con stays put. And, and I guess the closest we've come to consensus, at least talking about, is public record. And the other issue is, do we need to put in legal knowledge and legal research? And so that am I missing something here? But it seems to be boiled down to those two options.
Yeah, I would say, Evan, to that end, we have, in terms of options here for dealing with this, we could just keep everything the same, keep Rule 1.6 the same. Our opinion I think as we have previously discussed in subcommittee, our opinion kind of reaches the right result under the rule as it's currently crafted. One option, maybe the first option here, is if we just stay with the status quo as far as the rule is concerned, the opinion, I think, would need to or could benefit from some additional language that really makes it very clear that there are other options, as Suzanne was pointing out. Obtaining that informed consent, utilizing hypotheticals, although recognizing that that doesn't always solve the issue, especially when you're dealing with a high-profile case. But still speaking very generically about clients, is something that is expressly recognized in the rules. And I think maybe that would need to be teased out that much more. If there is any desire for a change, I think I'm hearing consensus about it's not the sexiest part of this conversation, but the legal research and legal knowledge aspect that, nobody seems to be in favor of this idea that confidentiality encompasses what a lawyer learns, the information that's gained during the course of the representation that essentially amounts to expanding his or her own legal knowledge based upon that legal research. And I think to some extent that would include the potential outcome of a case that becomes a part of the law. For example, an appellate lawyer that's representing somebody before the Court of Appeals, resulting in a published opinion that now becomes a part of the body of law in this state. I don't think that's something that anybody would say, well, that lawyer that argued that case is no longer allowed to reference that or speak about that or offer opinion on it unless they get their client's consent. That becomes a part of the law. So I think that part seems to be kind of there. I get the feeling that there's consensus on that.
There's consensus on that.
So, and that I think could be dealt with an amendment to Rule 1.0 as far as defining what information is considered confidential in the terminology section. As far as the public record / generally known, that is the part that I think we are struggling with the most, and therefore I think it really might need to go to essentially to a vote to see where exactly do we stand. Do we have a majority of the subcommittee in favor of exempting from the scope of confidentiality that which is in the public record? Or maybe if we want to go with generally known, like to Ellen's point before, it's actually perhaps a bit more narrow, because even if something is in the public record, it's not necessarily generally known. But maybe we start there just to answer that question with a vote. And if we don't have the support, then that can be the report back to the ethics committee.
Well, if we're gonna talk about that, Brian, I think it's got to have two qualifiers on it. One is embarrassing information, and two, as we've discussed, client gets a veto. And how we structure that is really problematic. But those are, that's got to be written in as part of it, and that's the troubling part to me.
Can we take a vote to see if we have a majority that just want to keep the rule the same?
Do I hear a motion? Todd?
So moved.
Second?
I'll second it.
Any discussion?
And just to be clear, this is a motion to keep Rule 1.6 as is. Is that
Yes.
correct?
Yes, and in Raycon to with just a few tweaks, to keep the 20 FEO 6. So no discussion. All in favor, raise their hand. All oppose. Bill, are you abstaining?
No, he's opposed.
Oh, he's opposed. Okay. All right.
I'm opposed.
All right. Well, the motion fails. All right.
Yeah, and Eben, I think this is one of those curious things we have of the subcommittee. We have 5 official subcommittee members, and that was kind of a 2-2. split. I know Colin, as an ex officio member of all these subcommittee members, voted opposed. So I don't know if Eben, you had a particular vote that you wanted to cast in this particular matter, but otherwise it would still probably end up, even if you voted in favor, it'd be a tie and the motion would still fail. So perhaps we just leave it at that.
Well, I'll be glad to weigh in. I ain't scared. I ain't scared to. I vote with Todd and Amy that we keep it as it is. So we're either 3-2 or 3-3, depending on Colin's status. Is he? I guess he's ex officio member. So does that?
I think as an officer, yeah, I think that's how
that gives him voting privileges. So, well, the perks that come with power, Colin. You know, you've dealt with it well over the years. You know, power does create certain cognitive distortions and dysfunctions that you somehow seem to have avoided.
I don't think so.
I do think, Eben, it's important in reporting to the ethics committee that even among the three, and correct me if I'm wrong, I think we three are in disagreement, because I think I'm the only one that would modify with respect to generally known, but not in the public record. And then others would say in the public record. And I think that's important if Brian is correct, and I'm guessing that he is, that this is representative of what we might get from either the committee as a whole or the bar as a whole.
All right. Well,
we have.
And I agree with you on that. Colin, do you want to say something on that? No.
Yeah, I mean, I think if we look at this as trying to do something that might improve this, I think we need to think about the practicality. And I guess my background is being a government lawyer. I mean, you know, I think about how this impacts public lawyers of, you know, does the Attorney General's staff have to get permission from the Department of Labor before they can make a comment about what went on in a courtroom? Or, you know, does the State Bar Council lawyers have to get permission of the State Bar Council before they can discuss in a CLE what went on in the courtroom? It just seems like to me that we've got a very impractical rule if we follow it the way it's written. And it seems like we ought to try to do it in a way that protects the public, but also is practical and maybe perhaps does some good.
Can I just respond to that really quickly, which is, couldn't there though be like a blanket rule that in the AG's office, you are allowed to speak? And I'm just picking an entity. There could be a lot, unless told otherwise, because then that's client informed consent. My concern is the other way around. Say you're defense counsel and you're representing someone, and in court, their wife testifies, well, I was having an affair on him this entire time. That's an open court. You're their attorney. That's now publicly known. Under the rule, depending on how it's framed, I know there's disagreement. It seems weird to me as their lawyer that I could then go out. So I take your point. I'm just trying to figure out how to practically solve it a little bit. And again, you've served more time in government than I have, right? We're in these two different settings. And I think that's why it's so good to have so many different people talking about this. But I just want to make sure we're not also sacrificing on the other side the defendant that something is said in court that truly is embarrassing, but would make a really good headline and get me more clients. So.
Right.
Eben, I had a question. Maybe this is for Brian and Suzanne too. Thinking about this, I sort of view obviously the Virginia case as an outlier, although I appreciate the tension between the First Amendment and a lawyer's rights. Is it true? I'm thinking about your email. Is it true that if we change the rule along the lines that we're discussing, we would be one of two, and there'll be 40 other states that have this same rule in effect, and it is followed as written, and in addition to the ABA? Is that right?
The ABA and 40 other states have the rule that we presently have on the books right now, 1.6. Okay. There are 10 states that have made varying modifications. And we looked where we looked that we liked the most was New York, and we looked at Washington, D.C. But we, we liked the New York modifications when we were looking at them. But do Ellen, Bill, Colin, do you want to try to cobble together an alternative that we can present to the ethics committee? Because I think this is going to be one of those lengthy discussions, and I have no idea how the ethics committee will vote this out. But do you guys want to suggest? I mean, I'm going back to our options that were changed to Rule 1.0, and that adds but does not include a lawyer's legal knowledge or legal research or matters in the public record. And
or maybe matters generally known, depending.
Yeah,
I think
that would be the I think that would be the minimalist change at this point that we could, that it may be the most palatable if it goes out of committee.
I think with Brian's help, we could probably put together something that might be at least an alternative to look at. I don't know that we can wordsmith it here today, but I think I think there's probably some ways he can help us.
Oh, here we go.
Here's Brian sharing his screen. So yeah, we've smithed it and resmithed it.
And this is what I have to say. I'm drafting this as we're talking, so this may not be my best work, but I think what I've done is, in looking at the terminology section, confidential information, if there is a desire to exclude from the definition of confidential information, legal knowledge, legal research, and information that is generally known, of course, we'll need to kind of carry over the idea of generally known information from 1.9. I believe it's comment 4 or something like that. Right. But I added in the "and is not likely to be embarrassing or detrimental to the client if disclosed," to put that additional check on the lawyer, at least the thought in the lawyer's head that even if something is generally known, it's my responsibility as your lawyer to evaluate whether or not this will be embarrassing and or detrimental if I disclose it.
This is like I'm sorry, Brian.
No, go ahead.
This is an amalgamation of New York, right?
Essentially, yeah. There's something that I mean, New York has. If I remember correctly, I think New York actually says that something is confidential if it's attorney-client privilege and if it's generally known in the trade or profession, or it's not generally known in the trade or profession and is not likely to be embarrassing or detrimental. Right. So we're not dealing with the attorney-client privilege. Right. We're still retaining the broad scope of information that's gained during the course of the representation.
Let me ask a question. Because I haven't read all this. Is there some definition somewhere of the phrase generally known? And is there some definition of the phrase not likely to be embarrassing or detrimental to the client?
To the latter, no. There is no specific definition of what is likely to be embarrassing or detrimental. If anything, I think that is that is going to be a kind of a circumstantial sort of review. I'll share the comment if I can pull that up fairly quickly.
There's a terminology section in the code. There's no terminology that defines generally known, I presume.
No, that's correct. But we do have a comment to Rule 1.9 about generally known, and that's what I'm trying. Oh, here it is. It's comment 8. Sorry, I said comment 4 before. And here it is in the center of your screen. Let me see if I can zoom in a little bit.
Yeah, I can't read that.
Oh, can you not read this part right here?
Now I can.
Okay. So the part that I've highlighted is our kind of definition for generally known. Like most things drafted by lawyers, it is vague. It is circumstance dependent.
And so we're going to, under, if we change this rule, then the grievance committee is going to be saddled with prosecuting grievances that may fall under this generally known language or the embarrassing or detrimental language as well,
Yes.
without any clear definitions of what that entails.
Yes, and I think, Todd, it's a fantastic point, and that's the thing that I have hesitancy on. As much as I'd like to think that we all can see where this is heading, but when it comes to matters in the grievance committee, we have lawyers that are over there dealt with by the grievance committee that toe that line and cross that line and can take advantage of those squishy situations, and that oftentimes can be where the most client harm is experienced.
Right.
And so that is something that you're right. This creates a standard that's very difficult to enforce. We do have this term in our rules already, generally known as in 1.9C, but it's limited in its application, and it's really limited not necessarily to disclosure, but to use of information, really to kind of avoid having a conflict with the former client. So it frankly doesn't come up all that often in the disciplinary context.
Right.
This would come up in the disciplinary context.
All the time. That's right. All right.
If we were writing with generally known, and I just pulled up New York to see how it compared to this one when Eben reminded me that that's what we had looked at. They actually use generally known in the local community or in the trade field or profession. So in other words, they are including some modification and definite modifier and definition of generally known in the rule itself, which wouldn't wholly address your point, Todd, at all.
Exactly.
But
right.
does include more.
Yeah. They're just saying, don't apply California standard to something that's involving New York is basically what they're saying. Right. I got it.
Yeah, I guess to that end, I do think that Catherine Jean may not be happy with me if we pass that type of standard in terms of enforceability. But again, it's one of those things that's I don't know. I write that and I shared that potential version, as a way to continue our conversation. I still remain torn.
Well, let me ask you this, Brian. Do we need to take a motion on that and see if we present that as an alternative?
I guess the reason that I'm hesitating to answer is because it's it's something that I just drafted today and just shared with everybody. I think maybe it'd be more appropriate, as much as we want to have some sort of product here. I wonder if this should be shared with the subcommittee for continued consideration and a subsequent discussion based if that is kind of where we are at. But I'm not trying to belabor this point. Again, it strikes me that, like we've talked about, when we're going back and forth so much, sometimes that may be an indicator that maybe we just haven't found the right solution. But nevertheless, I don't know if anybody, it's clear. I don't want to dictate exactly what the subcommittee should or should not do. If somebody felt that the version that I just created today is exactly what you were thinking is the most appropriate version, then I don't want to stand in the way of anyone making a motion.
But you know how the ethics committee is going to work. No matter what you draw, it could be perfect, and it's going to get hammered and wordsmith death in front of the full committee. So
right. Eben, to that end, we could just might suggest sharing this with the ethics committee. We don't necessarily need to have a vote and a formal recommendation, but maybe it's something that it would be interesting to hear the full committee on. We did that at the last meeting with another inquiry that was kind of producing a lot of difficult decisions, issues, kind of creating an impasse within the subcommittee. And it might be worth obtaining the full committee's perspective and really just kind of impression if they looked at that language to say, this is something that the subcommittee is looking at, we're opening this up to get the full committee's thoughts here.
Hey, Evan, just one clarifying point for the record. To the
For the
extent,
public record, so that
No,
it's generally known. Yeah, okay.
yeah, for that record, exactly right. Because whatever says going to be shared in the press probably. I just want to be clear. You've said several times, if I heard you correctly, that there's some consensus that has formed around any of this language. I just want to be clear. I've not formed a consensus around anything that we've said or that we're adding. I have not.
Right.
So I don't want the communication to the full committee to be that there's some consensus or unanimity, I guess is a better word. There could be consensus here even without me, but I don't want there to be some message that the committee is unanimous around X or Y, because I'm not unanimous around anything we've said.
Yeah, I think, Todd, maybe I was not very skillful in what I said, but as we went through the various options last time, A, B, C, D, and E, that as we went down the list, the most popular, or the one that was the most accepted, was the 1C, I think the 1C option. And that's what I meant. It doesn't mean that we've got consensus on the fact to report that back, but
Fair enough.
that was the most palatable of the options that we had.
Could we go to the meeting and say we don't have a consensus, and then can the full committee vote on whether they want us to continue to try to come up with changes, or could they vote at that point that they don't want there to be any changes?
I would report to the chairman that we're deadlocked, that we're a hung jury.
I mean, I just wonder what the vote of the full committee would be. And I don't know how many people are actually going to be there. So that's.
Do we then give the dynamite charge, Evan?
It wouldn't work. So,
Well, as a defense lawyer, we hate that anyway. So.
Yeah. Also called the Allen charge.
Allen charge.
Yeah.
I mean, it might be just a split among the whole committee as it is here. That wouldn't surprise me either.
There's not going to be consensus on the whole committee. I mean, it's going to be, if it came up for a vote like we did, whether to take status quo, stay as it is, or accept Brian's changes that, that Bill and Colin and Ellen are talking about. I think it's going to be a real tight vote at the full ethics committee. And maybe not. I guess it depends on how lawyers perceive the present rule to handcuff them in CLEs and other stuff. So, Abby, you've been quiet. You got anything to add?
No, I just appreciate being able to be here on behalf of NCAJ. This is something that they are closely watching. This is something as been alluded to between our CLEs and various member services that we have. Potential changes could have a significant impact, or maybe not. And so we just really appreciate being able to be involved. I anticipate that if something goes back out in publication, we will probably have significant comment or two.
Yeah. No question about that. Yes. Yeah. So, Brian, I'm hearing you. We really don't need to put to vote the right now the draft language that you've put.
I don't think so, but I will send to the subcommittee. I'll send that language out, if anybody wants to just kind of think it over. One other thing that I know Suzanne and I talked about that is probably not as attractive of an option, but if we wanted to, we could potentially try to, we're leaving the rule alone, but clarifying through a comment to the rule, just what this is and is not supposed to cover. That, again, the legal research and legal knowledge seems to be something that maybe not unanimous, but it seems like, that nobody wants to take or we generally don't want to take the position that confidentiality prohibits a lawyer from revealing their legal knowledge that they gained during the course of a representation. And we could clarify that via comment. We could also, I always kind of noticed in the comments, the language about hypotheticals is in paragraph or comment 4. It's a single sentence. And perhaps that is something that needs to be kind of like pulled out a little bit more to really emphasize to folks that, in this notion of wanting to talk about something that would ordinarily come under the scope of confidentiality, that lawyers, for the purposes of educating the public and or other members of the profession, are permitted to speak generically, and or hypothetically about situations, for the purpose of education. Whether that is in a group setting or a one-on-one setting, that's not something that I think the rule has. Again, it kind of goes back to the very beginning of this discussion where we realize what people are doing with Rule 1.6 is probably not in accord with what the language actually is. But maybe we need to reassess the rule and how the rules kind of, I guess, put forth this duty of confidentiality to match that which lawyers are doing, the good stuff that lawyers are doing, not necessarily to suddenly exempt and have a wild west of information, but to recognize that there is a need and a value, particularly for educational opportunities, be it to the public or the profession. And perhaps we can do that through a more strongly worded comment or a more kind of blunt comment. That could be something that clarifies folks in interpreting Rule 1.6. That way we leave the rule as it is without creating new practicality issues and just kind of, address the educational components separately.
But that still would not talk about generally known, or
it would not talk about generally known. No, it would be
public record.
Keeping the status quo, yes. But I think the issue seems to be, where the kind of that net positive you're looking for, Eben. What is the benefit? It is an education. It is in the lawyer having the ability to speak about something that they observed in the courtroom, even while they're representing a client. And I guess I saw it in the comments that we received on the opinion stuff, people talking about responding to press inquiries, after the representation is concluded, things of that nature. And if we want to recognize there's a value to that, perhaps we can, reassure lawyers. You speak generically about your case, that perhaps that's something that you can use for continued education purposes. The press inquiry, the newspaper calling about your role in a particular case, that would probably be a different sort of analysis. You can't really speak generically when they're calling about the case that you represented a client on 2 weeks ago. So nevertheless, it's an option is one of the things I just wanted to kind of throw out there.
Yeah, I mean, Mark Enriquez pointed out about, legal research and cutting and pasting, stuff that has been done in the past. But how many times have all of us gotten a cut and pasted with a former client's name with no word replacement in it? So, yeah. Anyhow, that's all right. Is there anything else, Suzanne? You're always figure out what else we need to do. What else is there?
I don't know what we need. I don't know what we need to do. I think we need to figure out what the full committee wants us to do.
All right.
I think we need to report to them that we're kind of deadlocked or at an impasse, and maybe like I said, maybe take a vote on if they want us to continue trying to come up with some revisions, or if the majority of the full committee thinks it's fine the way it is. But I don't.
Yeah, I really don't see Todd or Amy changing their minds on that. And since I've been, if I'm the tiebreaker, I'm gonna vote with them. But I just don't see the net positives, and I see a lot of negatives that happen.
I just think we need to report what happened. I mean, where we are, and get advice from the full committee. We don't have a consensus, so we don't have anything that we can present.
Get advice. We're going to get 18 separate pieces of advice.
That's right.
All right, well, anything else? If not, do we need to make a motion to adjourn? I guess, anybody?
So moved.
Second, anybody? All right. Suzanne, I look forward to seeing your minutes on this meeting. And
Yeah, thanks to everybody. I know this is a pain to talk about, but it's fun to talk about it with you guys. So
Yeah,
I think
this is
it's,
great.
I think it's super fun and super interesting.
Yeah.
But it's
Agreed.
quite a brain teaser.
if we stick with 1.6 as it's presently written, it's going to be incumbent on all of us to get out there on CLEs and educate lawyers as to what 1.6 really means, because I would say 90% of lawyers are ignorant about 1.6 and maybe higher, but
I agree with that. Yeah.
yeah.
When you say this is fun, it reminds me of an older lawyer who's deceased from Raleigh, Clyde Douglas, who used to talk about the organ grinder and the monkeys that would bring. He'd say, what's fun for the children is sometimes hell on the monkey.
You say.
And so I just think it's really interesting.
It is.
Yeah, well, it's fertile grounds for CLEs and for law school classes. So, all right. Is everybody going to be in Raleigh next month? Okay.
Not
Darren?
Darren.
Not Darren. He's going to go up to his mountain house and hide out. Right? I don't blame you. You got the crummiest job in the whole state bar coming up. Ask Colin. It is a thankless job, really.
Piece of cake.
A lot of work. Yeah, a lot of work. So, but you got a lot of support. Yep.
I think we already lost our professor. I think he.
He's excited to get to class and talk about this.
Right. That's right.
Or maybe he had a headache and he left. But
Yeah.
Maybe this is a little too much inside baseball. So. All right, guys, I'm out of here.
Thank
See
you,
ya.
Evan.
Thanks.
Thank
All right,
you.
Thanks,
Sam,
everyone.